Before the end of May, 5 men in 5 different states are scheduled to be executed. One is asking for mercy after being convicted of killing a young mother and her baby. One is on Texas death row for a robbery that prosecutors said began with $775 and ended with a retired professor dead in the trunk of her own car. One was convicted in Arizona after a survivor lived long enough to point to the man who set the fire. One is scheduled to die in Tennessee, while his lawyers and advocates say there is still DNA and fingerprint evidence that has not been fully tested. And one is set to be executed in Florida, more than 2 decades after a mother and her 4-year-old daughter were murdered. 5 death warrants, 5 cases, 5 stories that all end with the same question. What does justice look like when the punishment is final? This is not a celebration of executions. This is a documentary look at the crimes, the victims, the convictions, the appeals, and the controversies behind the 5 men scheduled to die in May 2026. In America, execution dates are not just dates on a calendar. They are the end of decades of court filings, victim impact statements, appeals, clemency hearings, and legal arguments. By the time a person reaches an execution date, the original crime may be 20 or 30 years old. The victims' families may have waited for decades. The prisoner may have spent more of his life on death row than outside it. And still, until the final moment, the case may not be over. A governor can grant clemency. A court can issue a stay. A new legal claim can appear. Or the execution can go forward. In May 2026, these are the 5 cases still on the calendar. The first case is Raymond Eugene Johnson. Oklahoma has scheduled Johnson's execution for May 14, 2026. He was sentenced to death for the 2007 murders of Brooke Whitaker and her 7-month-old daughter, Kaya. And the detail that makes this case so difficult to discuss is the same detail prosecutors used to argue against mercy. This was not only a murder case. They described it as torture. According to Oklahoma Attorney General Gentner Drummond's office, evidence at trial showed that Johnson attacked Brooke Whitaker inside her home, struck her with a claw hammer, then poured gasoline on her and her infant daughter and set them on fire. The Oklahoma Attorney General's office said Johnson's execution was scheduled for May 14th after the Pardon and Parole Board denied clemency. The Frontier reported that Johnson appeared before the Oklahoma Pardon and Parole Board in April 2026 asking for clemency. The board voted unanimously against recommending mercy. At the hearing, the story became 2 very different portraits of the same man. The state described a man with a violent criminal history, a prior homicide conviction, domestic violence allegations, and a crime that left 3 surviving children without their mother and baby sister. His legal team described a man who had changed over nearly 2 decades in prison. A man involved with church mentors, a man they said was no longer the same person who committed the crime. Johnson apologized to Brooke Whitaker's family during the clemency hearing. According to the Frontier, he said, "My crime doesn't define who I am. It defines a moment I deeply regret." That line may become one of the most important lines in this story. Because the question before the board was not whether the crime happened. Johnson had been convicted. The question was whether remorse, time, religion, or personal change could outweigh the horror of what he had done. The board answered with a 5-0 vote. No clemency. And unless something changes, Oklahoma is scheduled to carry out Raymond Johnson's execution on May 14th. But this case leaves behind a disturbing question. If a person commits an unforgivable crime, can the state ever recognize change? Or does the crime become the only thing that matters? On the same day Raymond Johnson is scheduled to die in Oklahoma, Texas has another execution on its calendar. His name is Edward Lee Busby Jr. Texas lists Busby's scheduled execution for May 14, 2026. The Texas Department of Criminal Justice says the offense happened on January 30th, 2004 in Tarrant County, and that Busby robbed and kidnapped a female victim, placed tape over her nose and mouth, and caused her death. Local reporting identifies the victim as Laura Lee Crane, a 77-year-old retired professor connected to Texas Christian University. This case began in a place that should have been ordinary, a grocery store parking lot. According to Fox 4 Dallas-Fort Worth, prosecutors said Busby abducted Crane from a Fort Worth grocery store parking lot, used her credit cards and a blank check, robbed her of more than $775, and drove her car toward Oklahoma with Crane in the trunk. Her body was later found near Interstate 35 in Oklahoma. That is the haunting center of this case. A retired professor goes to the grocery store. She becomes a random target. And the motive prosecutors described was not millions of dollars, revenge, or a complex plan. It was robbery. A small amount of money, a stolen vehicle, a victim bound and left unable to breathe. Busby was convicted in 2005 and sentenced to death. His case has been delayed before. CBS Texas reported that a previous execution date in 2020 was stayed during the COVID-19 pandemic. Now, more than 20 years after Laura Lee Crane was killed, Texas has placed him back on the execution calendar. This case matters for another reason, too. Texas is one of the most useful states for a channel like this, because after executions are carried out, Texas often publishes the inmate's final statement in its official death row archive. That means if Busby's execution goes forward, his final words may later become part of the public record. But before those final words, there is Laura Lee Crane, a retired professor, a grocery trip, a random encounter, and a death sentence. The third May execution is scheduled in Arizona. His name is Leroy Dean McGill. Arizona's Supreme Court issued an execution warrant setting McGill's execution for May 20th, 2026. In its official release, the court said McGill was charged for the murder of Charles Perez, the attempted murder of Nova Banta, 2 counts of arson, and 3 counts of endangerment. A jury found him guilty on all counts in 2004. This case has one element that makes it different from many death row cases: a survivor. According to AP, authorities said McGill threw gasoline and a lit match at Charles Perez and Nova Banta while they were sitting on a sofa inside a Phoenix apartment. Perez died. Banta survived with severe burns and later testified against McGill. In court, the survivor's testimony became central. Nova Banta lived. She identified McGill as the attacker, and that survival changed the case. Because this was not only a murder trial, it was also a trial where one of the victims came into court and told the jury who she said did it. The Arizona Supreme Court's release said the jury found aggravating circumstances, including that McGill knowingly created a grave risk of death to others, and that the murder was especially cruel and especially heinous or depraved. The court also noted that McGill had exhausted state and federal appeals by 2022. But his defense has still raised concerns. AP reported that McGill's lawyers argued for leniency based on abuse he suffered as a child, mental impairment, and psychological immaturity. They also asked Arizona's highest court to hold off on issuing the warrant while they sought to litigate claims, including alleged sentencing stage jury instruction issues. The court denied the request. So the story becomes 2 things at once. For the state, it is the story of a brutal attack, a dead victim, a surviving witness, and a jury that returned a death sentence. For the defense, it is the story of a condemned man whose background, mental condition, and trial process should still matter. But But the strongest narrative angle is the survivor. Nova Banta was not just evidence. She was a living witness to the crime. And if Arizona carries out the execution on May 20, Leroy McGill's case may be remembered as the case where a survivor lived long enough to send her attacker to death row. The question this case leaves behind is, when a victim survives and testifies, how much weight does that testimony carry all the way to the execution chamber?
The fourth case is in Florida. His name is Richard Knight. Florida has scheduled Knight's execution for May 21, 2026. This is the most emotionally difficult case in the May group because the victims included a child. NBC Miami reported that Knight's execution is set for May 21 for the 2000 murders of Odessia Stevens and her 4-year-old daughter, Hanessia Mullings, in Broward County. Other reporting says Governor Ron DeSantis signed Knight's death warrant in April 2026, making him part of Florida's recent acceleration in executions. NBC Miami also reported that Florida carried out a modern-era record number of executions in 2025. The case itself goes back more than 25 years. Richard Knight was convicted of murdering Odessia Stevens and her daughter in 2000. He was sentenced to death in 2007. Because this case involves a child victim and violent details, the facts are already heavy enough. A mother was killed. Her young daughter was killed. The case moved through trial, sentencing, and years of appeals. Now, more than 2 decades later, Florida has scheduled the execution. That is the angle here. Not just the crime, the delay, the time. 26 years between the murders and the scheduled execution.
For some families, that time can feel like endless waiting. For the legal system, it represents appeals, reviews, challenges, and procedural steps. For the person on death row, it is decades of living under a sentence that may one day be carried out. Florida's current pace also matters. This case is not happening in isolation. It is part of a state actively signing and carrying out death warrants. The final May case may be the most legally controversial. His name is Tony Carruthers. Tennessee has scheduled his execution for May 21, 2026. Carruthers was convicted and sentenced to death for the 1994 murders of Marcellos Anderson, Deloise Anderson, and Frederick Tucker. Tennessee court records from 2026 describe Carruthers' convictions for 3 counts of first-degree murder, 3 counts of especially aggravated kidnapping, and especially aggravated robbery. But this case is not only about the crime. It is about evidence. It is about self-representation. It is about whether Tennessee should carry out an execution while lawyers and advocates say certain forensic questions remain unresolved. The Death Penalty Information Center says Carruthers has long maintained his innocence, and that his lawyers argue forensic evidence has not connected him to the crime. DPIC also reports that his conviction relied heavily on jailhouse informant testimony, and that there are claims about untested DNA and unmatched fingerprint evidence. The ACLU has gone further. In April 2026, it filed a lawsuit challenging the denial of fingerprint testing. The ACLU says Tennessee plans to execute Carruthers while unidentified DNA and fingerprints remain unresolved, and that there has never been physical evidence linking him to the crime. These are defense and advocacy claims, not findings that overturn the conviction, but they are central to the current controversy. That distinction is important. Tony Carruthers has been convicted. His conviction and sentence have survived many years of litigation. But his lawyers and advocacy groups argue that before the state carries out an irreversible punishment, the remaining forensic evidence should be tested or compared. That gives this case the strongest documentary question of all 5. What happens when the legal system says a case is finished, but the condemned man says the evidence still is not? There is another issue too.
Amnesty International says Carruthers was forced to represent himself at his 1994 trial after disputes with appointed counsel, despite later objections and concerns connected to mental disability. Amnesty argues the execution would violate international law. Again, that is an advocacy position, but it adds to why this case is being watched closely. And there is one more layer. AP reported that the Tennessee Supreme Court recently blocked a lower court order that would have allowed media witnesses to observe more of the execution process. That means Carruthers' scheduled execution is also tied to a wider debate about transparency in executions. So Tony Carruthers' case is not just the final story in this video because of the date. It is final because it leaves the biggest unresolved question.
If Tennessee executes him on May 21st, it will not only be carrying out a sentence from a 1994 triple murder case, it will be doing so while his lawyers and advocates say forensic evidence still has not been fully tested. And once an execution happens, there is no appeal from death.
5 men, 5 states, 5 execution dates in 1 month. Raymond Johnson in Oklahoma. Edward Busby in Texas. Leroy McGill in Arizona. Richard Knight in Florida. Tony Carruthers in Tennessee. Each case is different. Some are remembered for the horror of the crime. Some are remembered for the victims left behind. Some are remembered for the legal questions that still remain. But together, they show what the death penalty looks like in real time. Not as history, not as theory, but as a calendar. A date gets set. A warrant becomes active. A family waits. A prisoner waits. Lawyers file. Courts respond. Governors decide. And then, unless something changes, the state carries out the sentence. By the end of May, some of these executions may have happened. Some may have been stayed. Some may be delayed. But the stories behind them will still remain. Because every final statement begins long before the execution chamber. It begins with a crime, a trial, a conviction, a victim, a sentence.